Go ahead.
Judge, very quickly, this is State of Florida versus Collier in AIER, case number 202754, CFNA. There was an issue with collateralization on a bond. It's been satisfied. I have the email from Ross Wiener, along with the copies of the stipulation.
Okay.
My client's been in custody about 4 days now without being able to do this. Are we able to get that on the record?
That guy's not gonna be. He has a hold. Okay, so what I'm gonna do is when the judge imposes the terms, I'm gonna highlight them, so you know that's actually what happened, okay?
Pre-trial and a TAD bond. Oh, you did the other one?
Oh, okay, so let me give this back to you.
I have copies.
And then, I don't know, who gets this? There you go. Have a great day. Okay, yours was
Moreland,
and
Moreland.
and Mr. Lewis, yours was
Jose Coleman on page 24, Judge.
Coma. Okay, I just have to do it by the names. Coleman, okay. Moreland, oh, you're right at the top. All right, I'll just do that one then. Hi.
Miss Martha Hanson, she's on page.
Okay, let me do this one since it's right on top.
I didn't know if you were taking the.
No, I know, I don't blame you. Mr. Lewis, and then I'll do yours. Okay, all right. This one is Aisha Chantel Moreland.
Yeah, there was no charge on the petty theft. So
Is
the
that you?
It's mom.
This month.
Okay, so go on.
So basically, no charge on the petty theft. They're alleging a resisting without violence. She supposedly was in a car outside of a store when a couple people allegedly behaved.
I didn't find PC on that
Yeah,
count.
so the thing is, Judge, it's the 948, as you know, the statute allows if the offender does not admit the violation at first appearance, the court may commit the probation or offender or may release the person with or without bail to await further hearing, notwithstanding 907-041, which I believe relates to the danger hearing stuff. That's not the case here. We did not find PC. I was going to argue, obviously, vociferously against all of that. The problem is now we do know what's going on with the courts this week. We also know Judge Casey is a pretty reasonable guy, so I'm going to ask you to cut her loose today because we don't need people clogging up the jails, and we know Monday morning after Judge Siegel and everybody sits down, we're going to be cutting them loose anyway. So you have the discretion. We're going to ask you to ROR her on the VOP, and we will deal with Judge Casey coming up.
Okay, so on count one is the petty theft.
That was not charged.
What does NC means?
No
No
charge.
charge, Your Honor. So it was no information, they count one
Oh.
petty theft. However,
Found no
the re-
PC on the
yes, the
resisting.
resisting without violence was charged. This is a violation of probation on a grand theft felony charge, case number 166303, CF10A. Your Honor, the state would object to
Why? What's your office policy on these what's going on this week?
Okay, wait. There's probably no office policy. This was issued
has to
at
be.
5 o'clock last
But this-
Friday
He
night.
should have been instructed on Friday what was going to happen.
Okay, stop.
and yes, Your Honor.
You may finish.
On the 2016 case at arraignment, the defendant was issued a no-show habeas. We're here now on a new charge for resisting without violence, a violation of her felony probation. The state is objecting, regardless of what's going on right now.
Okay, here's my question. I didn't find PC on count two, and count one was no info. So technically, I can give them, 48 hours to
Yes,
perfect?
But the problem is she's in jail and we have a crisis on our hands with the courts being closed starting tomorrow. We
Okay,
don't know what's going to happen. We know they're going to be, Judge Tudor already signed a temporary administrative order.
Okay.
Ending weekend
but the
warrant.
problem is that there's a violation of probation.
A 948 hold only, no warrant. I would agree with you if there was a warrant, you would not have any discretion, but it's a 948 hold. The statute clearly
Okay,
says.
948 hold is, I've been doing civil for a while, so.
Okay, so what happens is
Get
they
me
get
up to
arrested
date.
or on probation, the jail, or whoever it is, they slap a 948 statutory hold, which allows the court to hold them no bond pending a decision by the trial court whether to have to sign a warrant.
So there's none of that
There's
on
no warrant.
here.
If there was a warrant, that Imperato case with Judge Hurley would say you can't
Right.
touch it, but there's no warrant.
Okay.
Number one.
So
Number two, you may release on a 948 hold. It's at your discretion. Number three, you didn't find PC.
is there a
Number-
warrant that says no bond hold?
Your Honor, there isn't a warrant issued yet, but that's
But there will
because-
be.
Yes, there
No,
will
there
be.
may not be. We don't know. And
There
the
likely
jail's-
will
Based on the fact that there's a no info and no PC, what are you asking?
ROR judge, she'll deal with Judge Casey. I'm in Judge Casey's courtroom almost
All right,
every day.
I'm gonna grant the ROR.
And Your Honor, the state would object and
What?
request time of effect.
The state said it was no info.
Count two was not.
Count one
no.
was no charge.
But you found no PC on count two.
Okay, what does that mean, no charge versus no info?
Oh, as far as bond.
Is that just bond? It's
It
still a
is
charge?
charged with petty theft,
No
right?
info, Your Honor, would be if it got the case filing and they no information in after it was charged.
So it wasn't no infoed.
Your Honor, you're correct. It was
It
no
wasn't even
charge.
charged.
All right, I'm gonna leave my ruling the way it is. I have a lot of work to do.
ROR on this VOP 16 case, correct, Judge?
Yes,
Thank you very much.
okay. So, put that on here.
Have a good weekend.
Well, it's over.
So, right here.
Oh, that's right, sorry.
So you are, did you write it right here?
Found no PC on two, I mean,
Right,
Your Honor,
yes,
a NC is a no charge. We don't charge two petty thefts. Like, we don't charge two misdemeanors. So if you charge one, the next one will be a NC, means no charge.
all right. Katrina Janelle Ebanks. Battery causing great bodily harm to oh, I'm sorry. All right, let me just do this and then I'll call yours. Forgot. All right, I am gonna find probable cause. Got it. I do find probable cause. The bond is set at, state your recommendation, it just says 0.
recommendation would be a $500 bond, no contact with the victim, Ryan Ebanks.
Okay, all right. Someone with the technical abilities here can explain to me why, because the speaker's so loud I can't hear anybody in the courtroom. Oh, he turned it off, good. All right, can you repeat that, counselor?
Yes, Your Honor, the state would be requesting a $500 bond and a no contact with the victim, Ryan Ebanks.
Okay,
Your Honor, we would, in the PC specifically, it says that the victim is not going to prosecute in this case. And they do have to. We're not asking for no contact, we're asking if they're going to be doing the ROR, or if the victim has specifically said that he did not want to prosecute, I'm not sure how to do that.
okay, but the victim's not here and he's not telling me.
It says it in the PC. It says it on the last page that the victim is not willing to prosecute the defendant. They have a child together, and I'm asking if Your Honor would be willing to ROR.
All right, I'm gonna do no harmful contact, okay?
Are you going to
All right,
ROR?
no, it's a $500 bond.
Are
And-
you willing to place her on pretrial release? She can't afford a $500 fine.
Does she have priors?
Your Honor, she does not have priors.
All right,
In the state of Florida.
I'll let her, what does that mean?
Your Honor, I only.
You
have
haven't
access-
checked anywhere else, okay. All right, I'm gonna do the pretrial release.
Your Honor,
What?
quick question. Booking report indicated 0 months at current residence, place of birth is Jamaica. Are there any community ties? Yes, they have.
Okay,
What's that address? And how long have you been at that current address?
We didn't ask the specific address, so we didn't have the time, because like we have to get through everyone on the docket, so we didn't ask the address.
okay, all right. If you can figure that out by the end, otherwise I'm gonna make the bond $250. I have to move on now. I can't spend 20 minutes on each person, okay? If you can figure it out by the end of the docket, I'll do pretrial. Otherwise, it's $250 bond, and you have to, no harmful contact with the victim. Sure.
Is she talking to me or somebody?
Yes. What's your address, ma'am? Hello? Hello? What's your
Hello?
address?
1160 Northwest 47th Avenue, Lauderhill, Florida.
It's the same address that's on the affidavit. But he does not live there, Your Honor. Just so we clarify, he came over
Okay.
to see his son.
Who lives there with her?
Who lives with you, ma'am?
I live with his mom and sisters and grandmother.
And he doesn't live there?
No.
Okay.
My suggestion for pretrial will dependent verification, what when you say he's coming, don't want a
Thank you. Okay, I'm moving on. I'm looking for Mr. Coleman now. Can you state his full name?
Jose Damon Coleman, Coleman. He should be towards the end, Judge.
He is at the end.
Judge, if I
Okay.
could just tell you, this case is eerily similar to Mr. Jellen's case. He's here on a 948 hold. He was arrested for resisting without violence, running away from a police officer. There's a $100 bond already set on that case, and we're fine with that. The issue that we have, Judge, is he has a drug charge from 2011, 2014. There's a 948 hold. This is the only violation, this new arrest. Again, we know we're not going to be able to get him in front of Judge Murphy next week, which that hearing was set for next Tuesday. I would ask the court to use its discretion on Mr. Coleman because the original offense is so old and the only violation is this misdemeanor, to give him like a $1,000 bond. I'd be fine with that on the violations of probation.
And Your Honor, I apologize. I'm going to need a minute here. We're going out of order. I got to find the reset from yesterday.
All right, listen. I don't know why this was reset from yesterday. Anybody want to tell me that?
I can tell you, I was
Thank you.
here.
Okay.
Unfortunately, there was a miscommunication to Mr. Lewis when he appeared in court for Mr. Coleman. He was given
Okay.
at the end of the
Okay.
docket, the jail deputies informed us that there was.
An issue, not a medical reset, so they reset it for
Okay, I
today, and
see.
that's why I'm
Because
here again.
the judge yesterday found PC. I like to disagree with him as often as
And
possible.
if you could,
but-
on the misdemeanor, yes, ma'am.
But, you know, I'm going to go with what Judge Cohen did yesterday, that there is PC. Now, the problem that I have is that, which may be a little bit different than the case before, is that this violation of probation, there's two of them. And I don't really care that they're old. They're violated probation twice. And
Well, he
it
was on
appears to
probation for
me
two
that.
cases. He didn't violate twice. He was on probation for two cases, on the 2011
Oh,
case and
okay.
the 2014.
Okay,
The
well,
only
there's two
violation
cases he
is
was
this
on
new misdemeanor.
probation on.
Yes, ma'am.
Okay, and I know they're old, but I don't, to me, that doesn't make a difference. Now, it seems to me that the lawyers that are coming in today are basically saying, you know, there's no court the rest of the week, so you have to let our clients out because this is the last chance. I am sure that Chief Judge Tudor, as well as all the other judges, their divisions, will find ways to have these hearings. I'm doing telephonic hearings in civil court. I am not going to make a ruling today, coming in here and deciding for the courthouse and all the judges the appropriate way to handle their dockets, their cases. So I'm going to go with what's you know, there's two cases, violation of probation. I don't know that I'm even allowed to put a bond amount on them. I
You are,
would do
Judge.
that.
And again, because there is no warrant, there's
Okay.
no bond set. It's a hold simply that the.
I'll give it an
jail puts
amount
on.
then.
Thank you.
Okay, I'm gonna make it $1,000 bond on counts 2 and 3, and $100 on count 1.
Thank you, Judge.
All right?
Appreciate it very much.
And Your Honor, for the record, the state would object.
Hey, go post my
Same
bond now,
basis
man.
as the previous case. This is a violation of probation.
Yeah. Okay, moving on. Counselor, your client's name again?
Martha Hanson?
Good morning, Your Honor.
Good morning. Oh, she was at the top.
Five
All right.
on his docket.
This is Martha Hanson, grand theft. I believe it's first degree. And
ma'am.
larceny, 50,000, more than 65-year-old individual. Okay. Was this these add-on charges?
Yes, Your Honor, and I also had the opportunity to speak with the state in reference to her bond.
Okay.
Ms. Hanson is 72 years old. I have a indigent application, although I am a private attorney, Your Honor. I do expect that this case will go through JAC. The state did agree to reduce count 2 to 10,000.
In exchange for the level 2 release with a GPS monitor, Your Honor.
That-
The state would request a higher bond if that were not granted.
That is correct, Your Honor. And as to count 1, we would just ask for a reduction of 5, only because according to Ms. Hanson's financial records, she is on Social Security $953 a month. And I did speak to the bondsman. That $953 will post April 1st, and the bondsman is willing to work with her. So essentially,
Does she have any priors?
no priors whatsoever, Your Honor.
Okay.
And
I'm gonna find PC. I'm gonna count 1 is gonna be a $5,000 bond. Count 2 is 10,000 level 2 GPS monitor. Okay.
thank you, Your Honor.
Okay.
Have a blessed day.
You too. Oh, have a nice day. You don't need to add the last part. I'm sorry. Touch or strike domestic violence. This is Deborah Fasanello. Okay. You're charged with domestic violence battery. I do find probable cause. State, do you have a recommendation for the bond amount?
Yes, Your Honor. The state would request a.
There's no way we can lower the sound from the jail, anybody? Oh, okay. It's painful. Okay. All right. Counselor?
Yes, Your Honor. The state would request an $800 bond. The defendant was also involved in a 2015 domestic battery.
Okay. I'm going to, as I said, there, I find PC, it's an $800 bond. No contact. Do you live together? Oh, it's an ex-husband. No contact with the defendant. I mean, with the victim, I'm sorry. No contact with Dennis Kutuvaz. So, that's it. Okay. Next case, Angela Ann Langley.
Hi.
Hi. This is
Whatever you
a,
see, where I can
good
go.
morning,
Tamika Carr on her
Good
behalf.
morning.
city
wanna go home.
ordinance case.
Yes, Judge.
I
wanna
do
go home.
find probable cause.
Your Honor, she'd like to resolve today to time served if you're inclined to allowing her to do so. The city doesn't come on the weekends.
They don't, okay. All right.
And the offer's usually just time served.
Well, I know what it usually is, but if she has priors and has done this a lot, I'm not just gonna do what usually happens.
Okay.
Okay?
She's also homeless, Your Honor, and cannot afford a $25 bond.
Okay, I understand. However, you know, by her walking into the normal flow of traffic, that could cause not only her to get killed, but other people as well,
I
so.
understand, Judge, and if I also may, I work at community court every Wednesday. Unfortunately, because of what's going on, it's now been canceled for the next 2 weeks. I would otherwise have asked that her case be transferred there and that you ROR her to give her an opportunity to receive the services that are afforded by the city of Fort Lauderdale. However, because that's not an option, that's why I'm asking for her case to be resolved.
Well, I could RR her and she could still go
She
there.
doesn't have an address. She won't get notice of
Okay.
a future court date. She'll just be rearrested.
Okay,
Address, ma'am. I have an address. My address is 133rd Terrace, Lauderhill Terrace. I use co-op. It's
They
family
don't
health
receive their mail
health
there.
Okay.
service.
All right, ma'am. Do you want to resolve this case today?
I want to get released on ORR.
Do you want to resolve the case today?
Whatever, yeah,
Okay.
something like that.
All right, it's going to be, I'm going to.
I wanna get outta here.
Time served.
Thank you.
Thank you, Judge.
I get
Have
to
a good
go?
day, Angela.
Catrice
Don't go
Marie
back there.
Martin. Catrice Marie Martin.
Bonded.
Kathy Marie Grady.
No problem, Your Honor. Good morning.
Hi.
Hi.
Your bond posted? All right.
Yes.
Okay.
Thank you.
Courtney Nahima Zahar.
She's approaching.
Okay. This is, you're charged with DUI and DUI property damage. I do find probable cause. Your bond is set at 500 on count 1 and 1,000 on count 2. Okay? Melinda Fallon Ventre.
Paul Ryan, Your Honor.
What? Oh, Paul Ryan. Good morning. This is a violation of probation.
I just want to say that I was incarcerated this whole time. My probation was reinstated on March the 2nd. I was supposed to report the following day to being reinstated, but I've been held incarcerated this whole time. So I do believe the reason why I picked up the KPS is because I was incarcerated in jail at the time.
All right. Anybody have any information on this? State? Public defender? What? No?
Oh, Your Honor, not at this moment. I could look into it.
But she's correct, she never got released, to report to probation.
Okay. So I'm going to ROR you on the violation of probation. Okay?
Thank you very much, ma'am.
Marquetta Burgess.
No problem.
Good morning, Judge.
Good morning. You're charged with purchasing amphetamines, other scheduled drugs, and possession of cocaine. I do find probable cause. There's $1,000 bond on each count.
And Judge, I'm in dire need of a rehab.
Okay.
Hear me?
You could take that up with the assigned judge, okay? And ask them in jail as well. Wait, ma'am, can you come back?
Yes, ma'am. I haven't talked to attorney.
Your Honor, she can't afford the bond as as set, Your Honor. So we're asking if Your Honor is willing to lower the bond or place her on pretrial release.
Please.
State, or she have priors?
Yes, Your Honor. Possession of cocaine, 2012, possession of drug and paraphernalia, adjudicated guilty. Uttering forged bills, checks, drafts, or notes, adjudicated guilty. In 2010, there was 13 counts.
Was she charged on all?
Vehicle theft, yes, adjudicated guilty. Vehicle theft, 2009, adjudicated guilty.
Are these in where?
Sarasota, Broward for the.
Okay,
Yes.
I'm gonna move on, and I'm gonna keep the bond where it is, okay? Counselor?
Sincerest apologies, Your Honor. I forgot to ask if the GPS monitor fees can be waived. The state has no objection, but I just
If what? You're talking really fast.
I'm sorry. The GPS monitor fees for the level 2 GPS for Miss Martha Hanson. I failed to ask if the court will waive the fees considering she is.
I'm not gonna waive the fees.
Okay, thank you, Your Honor.
All right. Shwanda Robinson.
Hi.
Hi. All right, you're charged with purchasing amphetamines and a scheduled drug, and I'm going to find probable cause, $1,000 bond on each count. To your prior state?
Yes, Your Honor, one moment.
Benedetti.
And yes, Your Honor, there are priors. One moment, I'm verifying the birthday.
Kimberly.
Yes, Your Honor. The priors are possession of cocaine, 2006, adjudication withheld, and a contempt failure to appear summons, adjudicated guilty in 2017.
Okay, I'm gonna leave it the way it is. Okay, not at this time. To Kamari Chambriel Wright.
No problem.
All right, you're charged with possession of oxycodone, also a violation of probation from 2017. I do find probable cause. There's a no bond on the violation of probation. Last count. Okay. State, do you have anything you want to add to this, or?
Yes, Your Honor, it's a violation of probation. The state would object to a no bond hold being lifted.
Okay. Oh, is that what the violation's for?
Yes, when I looked at that today.
All right, I'm gonna make the bond $1,000 on the violation, on the no bond, on count 3.
Okay.
So it's 1,000 on count 1, 250 on count 2, and 1,000 on count 3.
Thank you so much.
That's easier. Kimberly May Benedetti.
No problem.
Your Honor, I represent her as only as to count 7.
I'm sorry, what?
I represent her as to count 7.
Got it. Which is a capious misdemeanor.
That's correct, Judge. She has an arraignment. Well, it says
You're-
April 3rd.
You're charged with possession of cocaine, possession of alprazolam, possession of fentanyl, possession of methamphetamine, possession of cannabis, and possession of drug paraphernalia. I find probable cause. Count 1 is 1,000, count 2 is 1,000, count 3 is 1,000. Count 4 is 1,000, count 5 is 100. The drug paraphernalia is 100. And there was also a capious on a municipal ordinance case. I'll make the bond on that one $50.
Thank you, Your Honor.
All right?
Miss
Ma'am, can you
Miss
come back?
Benedetti.
Benedetti.
I spoke with Miss Benedetti on the phone. She did inform me that she cannot afford a bond. She may have someone that could potentially post a bond, but she doesn't know if they're willing to do that, and they can maybe afford about $300 or $400. But she did inform me that she doesn't believe that they will post the bond. She said she is homeless and she can't afford the bond. So we're asking if Your Honor would be willing to release her pre-trial release.
Not at this time, but again, she could take that up with her assigned judge. Okay? All right, Brittany Charday Jones.
No problem.
Hello.
Hi. You're charged with burglary with assault or battery. I
Yes.
do find probable cause, and there is a no bond. There's no bond on that one.
I didn't speak to
Or-
attorney, and I'm
You spoke
7
here?
months pregnant.
Okay, just
Let us hold
don't
on.
talk about the case. We're here. We're gonna address it right now.
Your Honor, I did
Okay.
read through the probable cause affidavit. It looks like this argument happened with her, the father of her son. She did inform me that the father of her child, that she is pregnant with. Apparently, they had an argument, and it went from the mall to the car. That's why she's
Right.
being charged with a burg bat. He did indicate that he does not wish to prosecute on her case. So we're asking if Your Honor is willing to, and it says in the police report that he does not wish to prosecute, just so Your Honor is aware. And they do have a child in
State-
common currently, so we're asking if you're willing to RR her on this
Okay.
on this charge, Your Honor.
State, what is your
And yes,
position?
Your Honor, the state would object, as there is proof evident and presumption great as to the charge of burglary with assault or battery, which is a which is a charge that is punishable by life.
Yep.
The facts do indicate that
Make a finding.
there was in fact a burglary as Moore entered the vehicle.
Okay, you don't have to read it, I
Yes,
read it.
Your Honor.
All right, I'm going to, I'm not gonna change the, no bond based on what I've read.
Oh my gosh.
Here.
Did not make a finding of proof evident presumption rate. The prosecutor just said that.
I know.
So in order for Your Honor to hold, Ms. Jones, no bond, Your Honor must make a finding of proof evident presumption great. Your Honor can decline to find proof evident presumption great, find probable cause, and, either ROR.
And then I could give her a bond.
Or impose a bond, correct, but Ms. Jones cannot be held no bond unless the
Okay.
court makes a finding
right.
of proof evident
At
presumption
this time,
great.
I'm not gonna find, proof evident presumption great. And I am going to find that there is probable cause, and I am going to set the bond at, $5,000.
Thank you.
Thank you, Your Honor.
Angie Leticia, I can't. It's NDLOUVU. Or ND, what? Bonded. Okay, good. Grace Sherry Johnson.
Medical wrong, ma'am.
Audrey Francis.
She's a medical research, Your Honor.
Jerson Santos.
Mr. Santos, he's approaching.
Good morning.
Is that the main jail?
Main jail, ma'am.
Oh, I didn't know. Okay. Sir, you're charged with battery, domestic violence. I do find probable cause. State, do you want to be heard on the bond?
Yes, Your Honor. The state would be requesting an $800 bond and a no victim contact.
Do you reside with the victim, sir?
What does that mean?
Do you
What
live?
is it again, ma'am?
I'm sorry. Do you live with? Do you
Daria
live?
Santos, yes. Yes, I do live with her.
Okay. You can go back and get your anything you need with police escort, but there's no contact with the victim. You understand? You can't
How
call
long?
till you go to your regular assigned judge. But you can't.
Yes, ma'am.
You can't call her, you can't text her, you can't have a friend call her or text her for you, no contact.
Your Honor, can they have contact with regards
And
to
an
their kids?
$800 bond.
Can they have contact with regards to their kids since they do have
Yes.
2 kids in common? So through a third, do you want to do it
Yes,
through a
third
third
party.
Okay.
All right, Land David Bowman.
Main jail, ma'am.
Charged with battery, domestic violence. I do find probable cause. Anyone want to be heard on bond on this case?
Yes, Your Honor. The state would request an $800 bond and no victim contact.
I'm sorry, what was the amount?
800, Your Honor.
Okay. All right, do you live with the victim in this case?
Yes, ma'am, I do.
Okay.
I'm supposed to be babysitting our kid tomorrow while she works. She just got a new job, so.
All right. I'm going to find probable cause. It's an $800 bond. No contact with the victim. No calls, no texts, nobody doing it for you unless it's for the children and there's a third party that's assigned to do that. And you can retrieve your items that way as well from the home, but no contact. $800 bond.
Okay.
Carlos Alberto Dominguez.
Man jail, ma'am.
All right, sir, you're charged with domestic violence. I do find probable cause. Anyone want to be heard on this?
Judge, I did speak with Mr. Dominguez. I'm asking that the court consider, pre-trial release.
And Your Honor, the state would object. The state would be requesting a $1,000 bond and no victim contact.
Based on,
Your Honor, based on the facts in the case and the fact that there was a strangulation involved, Your Honor, I understand that's not the charge.
okay.
Just at this time, the charge before the court is a misdemeanor pepper strike battery. I'm asking that the court, if the court's not inclined to consider pretrial release, if the court's inclined to reduce the bond to $500.
I'll reduce the bond to $500. And no victim contact. You understand? No contact with the victim.
Yeah.
All right. Okay. Maykel Soka.
I believe this
Any of that
person needs an
Spanish?
interpreter.
Do we have that or no? Yeah, we do. Thank you.
You're welcome.
No, this is someone else. Charles Trincali. I'm on Maykel Soka.
Well, you're gonna eat him too.
Okay, thank you. All right, sir, you are charged with 2 counts of domestic violence battery, 2 victims, and, oh, I'm sorry, I didn't know. Okay. Oh, do you swear and affirm or affirm that everything, that you will,
Accurately?
accurately, thank you. I was gonna say adequately, but accurately is way better. Accurately,
Interpret from English to
thank you.
Spanish, Spanish to
Accurately interpret from Spanish to English and English to Spanish.
English. I do, Your Honor. For
All
the
right.
record, Igor Felicioni, Spanish interpreter. Good morning, Your Honor.
Good morning. All right. Sir, Mr. Soka, you are charged with 2 counts of domestic violence battery.
Señor Soka, a usted se le acusa de 2 cargos de violencia doméstica, agresión física.
Okay, and I do find that there's probable cause on both counts.
La Corte halla que hay causa probable para ambos cargos.
Okay. The bond amount, state, do you want to be heard on that?
Yes, Your Honor, the state would request a $500 bond on both counts.
La Fiscalía solicita una fianza de $500 para ambos cargos.
Okay, before I do anything, all right. I need another pen.
Your Honor,
Blue. Okay. All right, so we were on the bond amount. At this time, the bond is going to be $1,000 on each count. No contact with either victim. Okay?
Señor, en este momento, en esta oportunidad, la Corte fija una fianza de $1,000 por cada uno de los cargos y ordena que no haya contacto con ninguna de las víctimas.
And Your Honor, with regards to the second victim in this case, it appears that it is his daughter. So we're asking if he can have no harmful contact with her.
No contact.
Okay.
Su señoría, la Fiscalía solicita en este caso que dada que la segunda víctima es la hija del señor, se le reduzca la orden de no contacto. La Corte rechaza la solicitud de la defensa y repite su orden de no contacto con cada una de las víctimas.
Okay, thank you. Manuel David Segura.
Also Spanish.
All right, sir, you're charged with battery, domestic violence. I do find probable cause.
Señor, se le acusa de un cargo de violencia doméstica en marco de agresión física de violencia doméstica y la corte halla que hay causa probable.
All right, anyone want to be heard on the bond on this case?
Yes, Your Honor, the state would be requesting a $500 bond and no victim contact.
La fiscalía solicita una fianza de $500 por el cargo y una orden de no tener contacto con la víctima indicada.
All right. It's going to be $1,000 bond and no victim contact. Yes.
Eso es lo que tengo que pagar.
La corte ordena $1,000 de fianza y ordena que no tenga contacto con la víctima. La defensa solicita que pueda tener contacto con la hija y la corte lo permite.
¿Con el hijo o hija? No, tengo un hijo.
Hijo.
Sí.
Do you have a question?
Puedo tener contacto con mi hijo.
May I have contact with my son?
Yes, but it has to be through a third party.
Sí, pero tiene que ser mediante un tercero.
Ah, con mi hijo. Okay.
Oh, with my son, okay.
Pero para pagar la fianza, ¿dónde la pago? Yo no tengo bond ni nada.
How do I pay my bail? What do I do?
All right, you need to talk to an attorney and they'll explain that to you.
Señor,
all
usted
right?
necesita hablar con un abogado que le explique cómo es el proceso, ¿ok?
Or someone at the jail.
O alguien en la cárcel.
All right?
Alguien en la cárcel le puede decir cómo manejar eso.
All right. Gregory James Harper.
Me en jail, man. Pepe, sí.
Sir, you're charged with battery, causing great bodily harm, domestic violence. I do find probable cause. Anyone want to be heard?
Yes, Your Honor, the state would be requesting a $1,200 bond.
All right, I'm gonna set the bond at $1,200. I'm going to, there's no victim contact. Okay?
Yeah, okay. Charges.
Yes. You can contact your daughter with the assistance of a third party, but no contact with the victim, no phone calls, no conversations. Your friends don't contact her for you, your daughter doesn't talk for you. No contact, okay?
Thank you.
Jabari Miguel Daniel.
Me en jail.
Good
Sir,
morning,
you're
ma'am.
charged with domestic battery by strangulation, child abuse with great bodily harm, battery causing great bodily harm, domestic violence. I do find probable cause. State.
Yes, Your Honor, the state would be requesting a $2,000 bond on counts 1, 2, and 3. On 3, Your Honor.
Any
$500.
priors?
Your Honor, this is the first priors, but the request would be based on the facts in the case.
I would recommend $1,000 count one, $1,000 count two, and $500.
I'm gonna do pretrial. What did the state ask for?
Your Honor, $2,000 on counts 1 and 2, and a $500 bond on count 3.
Okay, I'm gonna make it 1,500 on 1 and 2 and 500 on 3. And no victim contact.
With regards to the children, I understand that since we're involved in this, should he have supervised contact with like a family member or something with the children?
Not at this time. At this time, no victim contact, no contact with the children.
1,500.
Come on, sit right here.
Okay, Ronald Diaz. Oh, do you have a question, sir?
Yes, ma'am. I I really can't afford it, and also the charge. I only had a conflict with my daughter.
Sir,
Mr. Daniel,
you don't
please
wanna
don't
talk
talk about
about
your
the
case.
case, all
I
right?
did
Yes, ma'am.
ask the court to reduce the bond. You heard me. I did ask the court to consider reducing the bond, or in the alternative, place you on pretrial release, and the court did reduce the bond. So your bonds are placed by the court.
Okay, and,
I never had a bond. I got reduced.
it's, what,
You
3,500?
It's $3,500.
$3,500 bond,
altogether.
okay? So you're gonna have to
Okay.
take it up with your assigned division, okay?
Thank you, Judge.
All right, Ronald Diaz, did I do that? No, okay. Ronald Diaz.
Main jail, ma'am.
Okay. Sir, you're charged with, battery, domestic violence, and there's two probation violations, 2004 and 2007. Is that right?
These are not Broward cases.
Oh, there you go.
They're day cases.
All right, well, there's no bond, and so I can't change those, so. I do find probable cause on count one. I'm gonna set the bond at, are there priors?
Yes, Your Honor. One moment.
I'm gonna set the bond at 3,000. No victim contact. Jamarion Lee?
Main jail, ma'am.
This is, ag battery. Knew or should have known the victim was pregnant, and it looks like it was a capias.
For Lee, we've got, the date of the offense, sorry.
So, probable cause,
March.
is there a bond on this? Because, well, I'll set the bond at,
Yes.
are you talking about this case? Okay.
I'm trying to find out the offense date, Your Honor, because he's currently on pretrial supervision on another case, and based on the offense date. Okay, it is revocation.
Okay, so you were on pretrial release on another case, it's being revoked. This case, I'm gonna set the bond at, $10,000.
In Your Honor, pretrial release is requesting revocation of supervision in case number 19006835 CFNA, leaving the scene of a crash with serious bodily injury, leaving the scene of an accident with injury.
All right, I'm going to, grant that.
I'm sorry, Judge, did the court set a bond
I did,
in this case, $10,000?
yes.
Is the court willing to consider reducing that bond,
For what reason?
based on his inability to post $10,000?
Okay, I'm gonna release it to 5,000. I mean, I'm sorry, I'm gonna reduce
Your
it.
Honor, do you have a PC for this case? Because this one just says a speeding ticket, like he was.
Oh,
pulled
wait,
over
was this the
speeding.
one that I? Right, but it was a capias, so I was gonna ask you about that. I don't have the
All right,
PC,
let
do
me
you?
see.
Yes, Your Honor, I have the PC for the 19 case. He had a,
Oh, I see, so,
non-custody habeas on the, December.
okay, that's what I thought,
Domestic battery case.
okay.
Is that a Broward case or
It is a Broward case.
I don't see? You don't have the case number? I'm sorry, because I'm not seeing it on Odyssey.
Jamarian Lee.
Well, it's all the same case.
Yeah.
This is all the same case.
No, they're two separate.
No, they're not.
The
I don't
Judge,
have the
I think-
accident in front of me. All
Correct.
I have
And
is the.
here's what's going on.
Yeah.
Mr. Lee is before the court for aggravated battery, knew or should have known pregnant female, as your honor already announced, in case number 2000546 CF10A.
Okay.
We, the public defenders, have not been provided a probable cause affidavit for that charge. So we are first asking if the court was provided a probable cause
No.
affidavit outlining the facts of that charge. So we really have to perhaps do this all over again because the court
Okay.
should make a finding.
Here's what I'm doing. I'm resetting this for tomorrow. Unless you have it. Okay, now I have the PC.
All right, so now the court will review PC for this charge.
Okay, now this occurred on December 7th. So today he was picked up on this case. He was never arraigned on this.
Correct.
Never arrested on it.
Correct. So it appears to be, from my experience, a not in custody capias.
Yes.
I do not see in the clerk's system if 20-000-546 CF10A is filed, but this.
Okay, based on everything, you have 2 counts, I have 1.
Okay.
So based on all of this, everything that I've been told and I've seen, I'm setting the bond at $8,000 and I'm also moving on to the next case.
Do you have like a physical case?
I don't know if you need this. There's like a hold or something.
She needs the PC back.
You do? I was gonna attach it to this, but okay.
I provided 2 copies to the public defender if you'd like one of those.
All right, if you can give one to the clerk, that would be great. All right, Sir Marcus Flulin.
No problem, Your Honor.
Give it to the clerk. Sir, you're charged with domestic battery by strangulation. I do find probable cause. Are there any priors?
Yes, Your Honor. One moment, Your Honor, I apologize. Yes, Your Honor, I'm seeing possession of cocaine, adjudicated guilty in Broward in 2005. Along with that, there was a resisting or obstructing without violence and possession of cannabis, 20 grams or less.
All right, I'm gonna find, well, there is probable cause. I'm gonna set the bond at $8,000. No victim contact. I see that they do have children in common, so contact with the children only through a third party.
Thank you, Your Honor.
You understand no victim contact means no phone calls, no texts, no texting other people to text for you, okay? All right.
Yes, ma'am. Thank you.
Latavius Gaines. Latavius Gaines. Main jail?
Yes, ma'am.
Okay. Your bond was posted. Alan Ryan
Your bond was
Benson.
posted, sir.
This is main jail, ma'am.
Thank you. Sir, you're charged with, well, I think this is an add-on. 3 more counts of petty theft. I do find probable cause, and the bond's $100 on each count. Okay? Brian David Dean. Yeah, it's just added on, sir.
Right there on that wall.
Brian Dean, municipal ordinance.
Yes, Judge.
Charged with disorderly conduct and obstruction, resisting without violence? Is that what it is?
I believe that's what it's supposed to be on.
Okay. I do find probable cause.
He indicated that he could afford his bond.
All right, so $100 bond just on count 2.
Thank you. Just
Benjamin
$100.
Benjamin Grant Dutcher.
No problem, ma'am.
All right, so you're charged with disorderly conduct, breach of the peace, resisting without violence, and a misdemeanor capias. I do find probable cause. No bond on count 1. Count 2 is $100, and the capias is $500. Sorry. What'd you ask?
She said. 009.
Gordon Cleary. Are you Gordon Cleary?
No, there's no man there, no man.
Gordon Cleary.
Man jail, please approach him, ma'am.
Sir, you're charged with trespass, occupied structure, conveyance, and removing a shopping cart without written authorization. I do find probable cause. Sir, do you want to resolve this case today?
You want to resolve it?
All right. It's going to be an adjudication court costs on both counts, and no return to that area and plantation, you understand? Do not go back to Einstein's Brother Bagels, the original pancake house. Okay?
Okay. Go ahead, step up.
Porter Brown. Did we lose video? Oh, there we go. I'm sorry.
Found it.
Mark Toby.
Man jail, he's approaching, ma'am.
Sir, you're charged with petty theft, and there's a misdemeanor capias. What's a capias for, Counselor?
One moment, I apologize. Your Honor, it was for trespass.
Okay. Sir, you want to resolve your case today?
Go ahead, say it again.
Yes, Your Honor.
All right. Where's the petty theft? I know. All right. On the petty theft, it's going to be an adjudication and court costs. No return to Walmart in Margate on Atlantic Boulevard, and count 2 is a trespass, and that's going to be an adjudication as well. Court costs.
Thank you, Your Honor.
Okay.
Yes.
Brian Adrian Hugh.
Medical reset, Your Honor.
Donald Cash.
North Broward. Good morning, Your Honor.
Good morning.
Good morning.
You're charged, well, it looks like these are add-ons. Burglary, unoccupied, grand theft, burg dwelling, 2 counts, petty theft, 2 counts, grand theft, and a burglary on occupied conveyance. I do find probable cause. Count 1, the bond is $500. Count 2 is 1,000. Count 6 and 7 is gonna be, well, it says no bond.
For count 6, Your Honor, it's a burg dwelling,
Yeah,
structure conveyance.
with armed.
While armed.
Okay.
The state.
All right, no bond on those. I am gonna find proof, evident, presumption, great. Next ones are $100, 1,000, 2 for 1,000, and 1 for 500. Okay,
Your Honor, I'm seeing 17 counts.
I did all of them. Okay. What? No? Yeah, I did. Oh, there's another page. I guess I did. Let me finish. 12 through 17, burglary unoccupied, unarmed, 2 of them, petty theft, burglary unoccupied, conveyance unarmed, and a grand theft. Setting each count at $1,000 on those. Okay. You want to be heard? All right, I'm going to move on. Shaquan Robertson. You're charged with grand theft. I do find probable cause. The
Yes,
bond.
ma'am.
Are there any priors?
Yes, Your Honor. Yes, Your Honor, there is a petty theft, 2018, adjudicated guilty. Another petty theft, adjudicated guilty in 2018. And Your Honor, there are, as you know, several pending cases as well.
Oh, this is just the add-on. All right. Well, I do find probable cause, and it's, for this count only, number 15, it's 1,000.
Your Honor, I have one concern, Your Honor. On count number 1.
Sir, please don't talk about the facts of your case.
I'm not at all. I'm not at all. I was here last week on an ad charge also, which was a burglary, occupied structure unarmed. It was changed, I think, 2 days later to a trespassing, unoccupied structure conveyance, but the bond amount wasn't changed. I have a $15,000 bond on the trespassing charge.
Okay, you gotta take that up with the assigned judge, okay? Alonzo Lewis.
Paul Ryan.
What? I'm sorry, Paul Ryan?
Yes, ma'am.
Okay. So you're charged, well, this is an add-on, retail theft, $750 and up. I do find probable cause, and this count is $1,000 bond. Next case, Gino Demetro. So you're charged with retail theft, $750 and up. I do find probable cause. This is a 4th count, so you must have other counts pending. I do find probable cause. It's $1,000 bond on that count. Alfonso Rogers.
Main jail.
All right, sir, you're charged with purchasing amphetamine and scheduled drugs. I do find probable cause, $1,000 bond on each count.
Judge, in this case, would Your Honor consider reducing the bond, or in the alternative, placing Mr. Rogers on pretrial release?
Does he have any priors?
Yes, Your Honor. Most recent priors, criminal 2015. Aggravated battery on a pregnant woman in 2012, adjudicated guilty. Trafficking in cocaine in 2008, adjudicated guilty.
Okay, I'm not gonna lower the bond, let's move
Thank you, Your
on.
Honor.
Xavier Houston,
Man in jail.
sir, you're charged with burglary with assault or battery. Um, Find probable cause. I'm not gonna find proof evident presumption great, I'm gonna set the bond at, $5,000.
In this case, would you consider reducing the bond to $1,000 based
No.
on Mr., okay, thank you.
Peter Lee Florimond,
Man in jail.
all right, I do find probable cause, you're charged with burglary with assault or battery. I'm not gonna find proof evident presumption great at this time, and I am going to set the bond at $5,000. Are there priors on the last two cases?
Yes, Your Honor. Starting with this case,
I'm sorry, Judge, who are we talking about?
I'm sorry, can I have the one from before? It is, I'll tell you. They're co-defendants.
Houston.
Houston? All right, let's just do Mr., yeah, both of them. Is that the last one we did?
yes, Your Honor.
All right.
Xavier Houston.
Yeah, let's, hold on to Mr. Houston and let's do Mr. Florimond since he's in front of us. Okay. Priors.
So we're on Florimond.
Houston.
Your Honor, there are no previous priors to Mr.
All right,
Florimond.
so that's a $5,000 bond. What about Mr. Houston?
Yes.
Yes, hello, Your Honor.
$5,000 bond, sir.
Is there any way for the bond to be lower? It's gonna be real difficult for me to pay that amount.
Does he qualify for pretrial release?
In addition to
I
that,
can't
there's
hear
gonna be.
anything.
In addition to that, later on, I know for sure there's going to be proof to drop the whole case, which is why I'm just
Sir,
trying
please
to
don't
get
talk about the facts of the case.
No,
We're
not
in the
the case.
courtroom, we're advocating for your release. The court, Judge, at this time, I'm asking that the court consider placing Mr. Florimond on pretrial release. If the court orders pretrial release, he will be placed on pretrial release.
Oh, that, it wouldn't be a charge that's eligible.
If you place him, we'll supervise.
Nope, I'm not gonna do it. Set a $5,000 bond, sir. Mr. Houston's case, does he have priors?
Yes, Your Honor. He does have a burglary of a dwelling that occurred in Broward County.
Okay. I'm going to change that bond to $8,000. Okay?
I was a minor for that charge, Your Honor.
Okay.
That's fine.
Take that up with the division judge. All right. Tommy German.
Mr. German is approaching, ma'am. Man in jail.
Good morning.
Good morning. You're charged with purchasing amphetamines, purchasing a scheduled drug, and probation violation on two separate cases from 2019. I do find probable cause, and there's a $1,000 bond on each count. The probation violations have a no bond hold. Okay. Yan Thomas.
Main jail, ma'am.
Sir, you're charged with purchasing amphetamines, purchasing a scheduled drug, and 4 traffic or misdemeanor capias cases. This case is, I do find probable cause. Count 1 is $1,000 bond. Count 2 is $1,000 bond. There are bonds on the capias. They're $250, $500, $500, and $500.
Judge, in this case, would Your Honor consider reducing the bonds, because there are so many counts?
Not at this time.
Okay, thank you.
Shadane Anthony Beckford.
Main jail, ma'am.
So you're charged with carjacking with a firearm or a weapon, robbery, firearm, and 2 traffic capias. I do find probable cause. I do find proof evident presumption great, so do I still have to give him a bond amount?
Once the court makes a finding of proof evident presumption great, it is in the court's discretion to then set a bond.
Okay.
At this time, Mr. Beckford, can you hear me?
Yes, ma'am.
Okay, are you able to afford any amount of bond if the court considers imposing a bond?
Yeah, it matters though. I think my mom could pay it, but it matters the price though.
Okay, what amount of bond would you be able to afford if the court considers a bond?
About like 300, maybe 350.
Okay.
I just got my income tax return back.
Okay, Mr. Beckford. Judge, in the alternative, Your Honor, it is in your discretion to
I know, I could
place
put him on,
terms
but
of
I'm not
release.
going to.
Okay.
All right, I'm gonna set the bond at, count 1 is gonna be 2,000, and count 2 is gonna be, 3,000.
And Your Honor, for the record.
And no victim contact.
The state would be objecting to lay a record for count 1. It's a charge that's punishable by life. Your Honor did find proof evident presumption great. Just to fill you in on the facts of the case again, I'm sure
I read the facts.
Yes, Your Honor. This involves semi-automatic firearms where 2 individuals approached the vehicle with these firearms out, stealing a car.
Oh, this was the one where they didn't even know this person. All right. You know, at this time, I'm going to it's gonna be no bond on these cases. Okay? On both counts, no bond, sir. Joseph William Sylvester.
Main jail, ma'am.
Count 1 is resist an officer with violence. Count 2, corrupt by threat, public servant. Is there any way you could, thank you. Leave the scene of the crash involving damage to property, reckless driving, resisting without violence, failure to report accident, and 7 is battery on an officer. I do find probable cause. Count 1 is a $500 bond. Count 2 is a $500 bond. Count 3 is $100. Count 4 is $100. Count 5 is $100. Failure to report. Count 6 is going to be $100. Battery on a law enforcement officer is $1,000. Okay. Next case, Andre Nelson.
Main jail, ma'am.
This is a violation of a risk protection order. I'm going to find probable cause. I'm going to set the bond at $1,000.
1,000.
Kelsey Smith.
No problem.
And Your Honor, if we may address Andre Nelson as well, before we move on, the state would be requesting a high.
Yeah, I handle that. Let's move on. Kelsey Smith?
Yes, ma'am.
Okay. Burglary, unoccupied dwelling, criminal mischief. Is this a KPS? Yeah, there's a warrant. So it's a no bond. Dominique Huzer.
Main jail, ma'am.
What does that mean?
What, I'm sorry, did you please tell me what case we're on?
Kelsey Smith.
Okay, and Your Honor asked, is this
Yes,
a warrant, right?
It looks like a warrant.
So it's because it's not in custody information that was filed?
Okay.
Mr. Smith?
Yes.
Okay, there was a not in custody information that was filed, and then once the not in custody information was filed on December 12th, 2019, the clerk's office issued the KPS. And the KPS is held for the court to set a bond. This is a second-degree felony, and it is entitled to be either released on bond or on pretrial release if the court is inclined to consider. This is not a
Okay. Bond is 2,500 on count one.
Mr. Smith, did you hear the court? Your bond is $2,500 on count one.
Yes, ma'am.
Thank you.
And 500 on count two. Dominique Huzer.
Main jail, ma'am.
All right, this is a grand theft of firearm, possession of a weapon by convicted felon, municipal ordinance. I do find probable cause. Count one, the bond is going to be 2,500.
And Your Honor, if I may, before we
Yes.
separate, there is a home invasion in his priors,
Okay.
which he was adjudicated guilty on.
All right, and a $5,000 bond on count two. And a $100 bond on count three.
Judge, will the court consider reducing those bonds at
No.
this time or place? Okay, thank you.
Roger Gedome.
Main jail, ma'am.
Is Mr. Shayette now the, oh, it's not Mr. McLawrence anymore. Okay. All right, sir, this is a violation of probation, felony, in 2015, and a U.S. Marshal hold. Okay. Randall Johnson.
Reset, ma'am.
James Major.
Main jail. He's approaching.
Sir, you're charged with DUI, alcohol, drugs, second offense. Also probation violation that has a no bond hold. I do find probable cause, the DUI bond is $1,000. Thank you. Trayvon Leroy Williams.
Champ, I want to be able to speak with.
Okay, there was no PC on this one, so. So you're charged with grand theft auto, operating valid license, and a KPS out of misdemeanor court. Does anyone want to tell me why there's no.
Probable cause affidavit, Your Honor, attached to your.
It just says he was detained and arrested for knowingly depriving the victim of a vehicle.
And yes, Your Honor, I have a,
Apparently there was a arrest 2/10/20.
Your Honor, I'm looking to see if my records have any other supplemental reports. The victim would be Tynesha Mitchell.
What do you want me to do with this case, State?
Your Honor, if Your Honor's not inclined to find probable cause, we would ask
All right, no PC.
for 48 hours to perfect the.
I don't know what's going on with this. There's already a case number for this date of incident, and now there's a new case number for the same date of incident, same charge.
Okay, well,
I'm asking that the court consider releasing Mr. Williams' ROR.
no. All right, Eric Mitchell.
So about the,
I just said no PC of 24 hours to perfect.
okay.
Can I speak?
Go ahead,
Can I
sir.
speak on my own behalf?
Do not talk about the facts of your case, sir.
No, I know that, Your Honor. The only thing I would like to say is, Your Honor, is I don't understand why, but the petty theft, I understand that, there was put in a motion to refile for that court date because it was just a play, like if something was wrong with the date, I showed up to court on the 3rd.
Okay, sir,
and the judge
you're
said I was supposed to
you're
be there on
talking
the
about
2nd.
things that can affect you, so the judge reset your matter for 24 hours, and at that time, the court will reconsider whether there's probable cause for your case.
Okay?
So you're coming back tomorrow.
Okay, wait,
What? Go ahead, sir. Tomorrow. Eric Mitchell,
Main jail, ma'am.
charged with petty theft and criminal mischief. I do find probable cause.
Judge, will the court consider reducing Mr. Mitchell's bond or placing him on pretrial release?
Does he have priors?
One moment, Your Honor. Yes, Your Honor. There's a burglary of a dwelling and a grand theft, both adjudicated guilty in 2013.
All right, I'm gonna find, as I said, there is probable cause.
Yes.
He's what?
And there's a pending case as well.
Hey, Young.
For grand theft.
All right. On count one, I'm gonna set the bond at 3,000. And count two is 3,000. Okay.
Young.
Yes, sir?
Young. If you look at the facts of what happened yesterday, ma'am, it's all this here, the criminal mischief. I understand that, but
Sir,
the theft.
Sir.
Mr. Mitchell, please don't talk about the facts of your case. And
Today's
I'm not talking about no.
Judge, I do have one concern regarding Mr. Mitchell's case,
I
however.
started jobs.
Mr. Mitchell, please let me advocate on your behalf. This came in as 2 misdemeanors. So I understand Your Honor set the bond for count 1 at $3,000, but count 2 is also a misdemeanor, no charge. So there shouldn't be a bond imposed.
Okay.
And Your Honor, with regards to count 2, I don't see anything that was stolen from the store.
okay,
Only the criminal mischief.
All right, I'm not putting a bond amount on it. So it's only 3,000 on count one.
No, that's
okay?
what I'm referring to, the petty theft. There is nothing in the PC that states that anything was actually taken from the store.
Yes, there was. That machine.
That's the criminal mischief. It said it was destroyed. Like, that he threw the machine. That's what the allegation is. That's the criminal mischief. But the actual petty theft, there's nothing. It said he tried to return a pack of cigarettes. They're not saying he stole the pack of cigarettes. So I'm not sure why he has...
He picked up the machine, he ripped the cord out, taking possession of it, and depriving the store of the ability to use it. That's the petty theft. Okay?
That wouldn't be the criminal mischief, since he
No,
destroyed the machine?
he took it and he deprived them of the use of it. Okay? All right. Count one. Next case, Jafari Diaz.
Manager.
Sir, you're charged with flee. Thank you. You're charged with flee, attempt to elude a law enforcement officer, driving while license suspended, permitting exterior riding, 2 counts, and failure to wear a seatbelt. I do find probable cause. Are there prior fleeing and eluding?
One moment, Your Honor.
Judge, while the state's looking that up, may I also just address that count 2 in this matter is also no charge, and then 3, 4, and 5 on the dockets reflects not for magistrate. I
Right.
think those, okay,
I
so
got that.
Your Honor's considering the
Yeah,
bond
just
for
on the
count
count
1.
one,
Okay,
yeah.
thank you.
And yes, Your Honor, there are priors, Berg of a conveyance in 2017, criminal use of personal ID in 2017 as well, fraudulent use of credit card. There's also attempted burglary of a conveyance.
Are these in, do you know what county these are in? I don't see any of
St.
those.
Lucie County. 2 counts of attempted burglary of conveyance.
Or St. Lucie, ma'am?
Oh, no, Mr. Diaz, don't speak. We're in court talking for you with the judge to see what bond she will impose.
And another count of burglary of a conveyance.
Okay. All right, count 1, the bond is gonna be 2,500.
Okay, Mr. Diaz, you have to post the bond for $2,500 to be released.
So is that 250, ma'am?
Yes, sir, you'll deal with that with the bondsman.
Yes, ma'am.
All right. Charles Trincali.
Manager, ma'am.
Count 2 is a VOP. Sir, there's a, Sir, there's an out-of-county hold, and there's also a KPS violation of probation. Says the out-of-county hold has a bond, but I don't know how that works. But there's no bond on the KPS violation of probation. Okay? Yogesh Sharma.
Yeah, go ahead.
Question, is there any way I can go home? I'm at the risk of losing everything, including my life with my medical condition here. If I stay here, I don't understand what's going on.
Okay.
I was never
Sir,
contacted by.
are you taking your medications? Do you have medication?
I am.
Judge, can we place this on a brief recall, please?
Sure.
Thank you.
Okay.
What does that mean?
All right. Next case. Can I call another case, or you want me to?
Yes, go ahead, Your Honor.
Okay.
Hello?
Yogesh Sharma.
Hello?
Sir, you're charged with failure to stop or remain at an accident involving non-serious injuries.
Yes, ma'am, but I was coming out from
All right, sir.
work.
Don't talk about
Don't
the facts
talk
of the
about your
case, sir.
case. I'm gonna set your bond, I do find probable cause. I'm gonna set your bond at $500, okay?
Okay, can you hear me? Okay, Mr. Trincali, first of all, what's the out-of-county hold?
Philip Siblis. I don't see anyone there, so.
Just wait.
Sir, these are 4 counts. This is 4 counts of a violations of probation. 1, 2, 3, 4 different cases. 3 from 2012, 1 from 2011, and they are no bond. Okay? David Heckel.
Medical law, ma'am.
Josjuan Suarez.
Your Honor, I apologize. David Heckel, that was on a medical reset?
Yes.
Good morning, Your Honor.
Sir, you're charged with burglary, unoccupied structure, unarmed. I do find probable cause. Anyone want to be heard on bond?
Yes, Your Honor. The state would be requesting a $2,000 bond.
Let's see, burglary, unoccupied structure, unarmed.
Mr. Swart, go ahead.
They're asking for a $2,000 bond. Is that okay?
Oh,
I need to.
are there priors?
Hello?
It's a burglary.
It signed me out for some reason.
Mrs. Suarez. Mrs. Suarez,
Yes, ma'am.
can you afford the $2,000 bond?
Yes, I could. However, I would like to mention that I don't have any prior proof of record. I'm pretty clean, and the reason I don't want to state facts of the case, but the reason why I went and did that is I needed my
Don't
keys.
talk about facts of the case.
Don't do it. Don't talk about your case, sir. All right, I'm gonna set the bond at 2,000. I'm
No
gonna.
serious priors, Your Honor.
All right, I'm gonna set it actually at 2,500.
It's $2,500.
Yeah. Okay. Tevin Phillips.
Okay, Mr.
Good morning, Judge.
I don't have any more PC either.
Oh,
I
they're
think I've
recessed.
Yes.
I don't know why they're resets, to be honest with you, because the judge yesterday found probable cause and set the bonds. So, I don't know why they called you up again, sir. Sorry about that. Oh, medical loan? All right. You're charged with battery, possession of methamphetamine, resisting without violence, touch, strike, cause, harm or death, police. I think it was the dog. This is the one where you kicked the dog. All right. Count 1 is 2,500. Count 2 is 2,500. Count 3 is 2,500. And count 4 is 10,000. That was from yesterday's judge. Tevin Phillips.
Your Honor, Mr. Phillips cannot afford that bond, the bonds as they are currently set. We're asking if Your Honor is willing to place him on pretrial release or, in alternative, reduce his bonds to nominal bonds because he can't afford those, Your Honor.
Not at this time. I mean, does he have priors? Oh, okay. Well, I'm gonna go with what the judge yesterday ruled, and then you could take it up with, you know what? I'm gonna reduce count 4 to 2,500.
All of your bonds are $2,500 for counts 1 through 4. It's $2,500 each.
All right. Mark Tyndall,
Medical reset, Your Honor.
Travis Cook.
Excuse me, Your Honor.
Yeah.
Your Honor, can you hear me?
Sure.
Yes, ma'am. I don't understand how did I get a battery on the dog and I got bit by the dog. All I was trying to do was protect
Please don't talk about facts of the case.
You'll deal with that with the assigned judge, okay? And your attorney. All right. Is this a medical reset? Travis Cook was up yesterday. Nothing on Travis Cook? How about Justin Shelton? Okay. Justin Shelton. All right, and then the last one is Jeffrey Reese.
What happened to Justin Shelton?
I don't know. It's not here.
Is he a medical reset?
Mr. Reese, medical reset.
Okay, Reese is medical reset and Bernie Holcomb.
Medical reset, ma'am.
What about?
What happened with Mr. Shelton here?
Medical court reset.
All right, so what about that one? I don't have it anymore, so I don't know who the defendant is.
Judge, we can recall Mr. Trincali, please. Charles Trincali. Mr.
I need the paperwork, I'm sorry, but, okay, can you bring Mr. Trincali, please?
Okay.
He's present, ma'am.
Thank you for allowing me to recall the case.
I'm sorry, I just don't have the paperwork, so we'll find it.
So it appears what's
Well,
going on is that Mr. Trincali is on probation in 18002718 MU 10A, a misdemeanor case. And a long time ago, it looks like, from the clerk system, that there was a affidavit and warrant for violation of probation signed October 2nd, 2019. In the same entry in the clerk system, I can't tell if that was resolved. I
Thank
can't
you.
tell, some amounts are imposed for costs. And then there's another entry in the clerk system for fees due December 17, 2019. The next entry in the clerk system for this misdemeanor case is March 14, 2020, capias served. I don't see what capias was served. Mr. Trincali also does have the out-of-county hold, as Your Honor already addressed, but that has a bond. So because we don't have a warrant in front of the court or a capias in front of the court, I'm asking if the court will consider releasing Mr. Trincali, ROR or on pretrial release so that he can deal with his out of county hold, which I believe is Orange County. In order for him to deal with that, he will have to post that bond anyway.
Right.
But if Your Honor will consider releasing him on this violation of probation.
What, the violation of probation, it's division MU, or cases are MU, what is that?
Yes, Your Honor, MU would be the designation for a DUI misdemeanor.
Oh, they changed that, right?
My
Right.
interpretation of the, I guess,
So he has a capias, or, no, he has a violation of probation on a DUI, is that? No? Okay, it says no bond, division Gottlieb, violation of probation. I am going to, it's gonna be a no bond on count 2, all right? Count 1 is $1,000 bond, but according to what I have in front of me, it does appear that he has a no bond hold. I don't know why, I don't. Okay, well, maybe now he'll get to do it. Okay. So you'll go to your original assigned judge, Gottlieb. At some point, I don't know when they're having, well, maybe they'll do them all video. I don't know. Okay? But you'll talk to an attorney. All right? Is that a wrap? Anyone else have anything? Okay. Have a great Sunday. Wash your hands. Thank you. How do I turn this off? I don't know. I'll go in the other room. They probably turned it off.
It's not.
All right. Well,
What?
Okay, I'm not leaving yet. Yeah, it only had one count. I didn't see two.
The second one is leaving scene of the accident with
Oh.
injury.
Okay. I'll just make it $100.
Judge, I'm sorry, did something, what just happened?
I just put on a leaving the scene of an accident $100 bond on a pre-trial. Or was it pre-trial?
For who?
That's Lee. Jamar,
Here, do you guys need that?
You know what page he's on?
Okay, it was Jamie and Xavier Lee leaving the scene of a crash with serious bodily injury and leaving the scene of an accident.
This is the
He was
main
on
deal, you
pre-
guys are still on the speaker.
Oh, okay. I don't know how to turn it off. Let me try to figure this out.